What happens when the person at the center of one of America's most disturbing child abuse investigations suddenly collapses before facing a judge? Is it just a medical emergency, or the beginning of a twist no one expected? And why are the newest developments raising even more questions than answers? The Ohio House of Horrors case has taken another shocking turn. Just as the grandfather prepared to appear in court, everything changed in an instant. Since then, new court filings, legal motions, and unexpected developments have left investigators, legal experts, and the public searching for answers. But here's what's truly unsettling. The more information that's released, the less this case seems to make sense. In this video, I'll break down the latest developments, uncover the details most reports only briefly mention, and connect the pieces that reveal why this case may be far more complicated than it first appeared. June 30th, 2024. Vinton County, Ohio. Deputies arrive at a home on Omar Street to serve a warrant. Something routine, unrelated to child welfare. Just another day in one of the smallest, quietest counties in the state. They force open the door, and what they find inside will haunt them for the rest of their lives. 16 children, ranging in age from 18 months to 18 years old, confined to a single room, measuring 12 feet by 12 feet. A space smaller than a standard prison cell built for one inmate. Covered in feces, unable to communicate. Some with medical conditions so severe that 2 would be airlifted to trauma centers within hours. One child was listed in critical condition. But here's what makes this even more disturbing. No one called 911. No one reported these children missing. No neighbors knew they existed. They were discovered the way you discover something that's been sitting there, untouched and unseen for years. And within weeks, the grandfather accused of keeping them there would collapse on his way to court. Walk free because the county couldn't afford to keep him locked up, and his own attorney would question whether the man even understood what he was being charged with. This is the case investigators are now comparing to the Turpin family. And the parallels, according to the detective who led that investigation, are not reassuring. If you're interested in cases like this, where the system fails and the truth takes years to uncover, make sure to hit that subscribe button for reopened crime scenes. We're just getting started, and there's a lot more to this story than anyone expected. Let's talk about the space for a second. 12 feet by 12 feet. That's 144 square feet total. Now divide that by 16 children. That gives each child 9 square feet. Smaller than a twin mattress. That's before anyone moves, before anyone sleeps, before anyone tries to exist in a room that was never designed to hold that many human beings. Human waste was found throughout the home. Several of the children reportedly couldn't speak. One 18-year-old, according to investigators, couldn't write her own name. Ohio Attorney General Dave Yost described what deputies found in terms that were hard to hear. He said the children looked almost like feral animals. The county sheriff went further. He said his livestock was kept in better conditions. And then the Attorney General clarified something that should have been obvious, but somehow needed to be said. No cages were found in the home. Think about that. The bar had dropped so low that the absence of cages was what passed for good news. 7 of the 16 children were hospitalized immediately. 2 had to be airlifted by a medical helicopter to trauma centers in Columbus. 1 was fighting for their life. And none of it happened because someone called for help. It happened because deputies opened a door they had no reason to believe would lead to this. The neighbors didn't see it coming either. One told the Associated Press he had never seen a single child at the property. Not once. Another said she glimpsed some of the kids at a yard sale. She noticed they were dirty, but she assumed they'd just been playing outside. Normal kid stuff. She didn't think anything of it. She's losing sleep over it now. Because the truth is, these children existed in a home that from the outside looked like any other house on the block. They lived in a community where people went to work, mowed their lawns, waved at their neighbors, and somehow 16 children spent months, maybe years, locked inside a 144-square-foot room, and no one knew. No schools reported them absent. No doctors filed concerns. No family members raised alarms. The system designed to catch this kind of thing never even got close. As far as the world was concerned, these children didn't exist. 4 people were arrested that day. Elizabeth Sider, the mother of all 16 children. Jacob Sider, the father, and the paternal grandparents, 73-year-old Gary Sider Sr. and his wife, Christina. Each of them was charged with 16 counts of child endangering. That's a second-degree felony in Ohio, carrying a potential sentence of 2 to 12 years per count. Do the math. We're talking about the possibility of nearly 2 centuries in prison for each defendant if the sentences ran consecutively. All 4 pleaded not guilty. All 4 were held on $300,000 cash bonds. And for a moment, it looked like the case would move forward the way these cases usually do. Arrests, charges, trials, justice. But then something happened that no one saw coming. Gary Sider Sr. was being transported to a preliminary hearing when he collapsed. Just fell, right there during transport. He was rushed to Ohio Health and Wellness Hospital in Athens, where doctors ran tests and determined he had a serious medical condition, one that required specialized care at a larger hospital outside the area. No one has said publicly what that condition is. His attorney declined to even name the hospital he was transferred to, citing medical privacy. But what we do know is this. Because Gary Sider Sr. hasn't been convicted of anything, the cost of his medical care legally falls on the county, not the state. And Vinton County, the least populous county in Ohio, a place so small that the grand jury only meets every other month because there just isn't enough case volume to justify more, could not absorb that cost. Prosecutor William Archer was direct about it. He said the community wasn't at risk because of the bond modification. This wasn't about trust. It was about money. Keeping Gary Sider Sr. locked up while covering the cost of his ongoing medical treatment could have bankrupted the county. And local taxpayers weren't going to be the ones covering it. So the judge converted his $300,000 cash bond into a $300,000 recognizance bond, which essentially means the court is trusting him to show up. If and when he's released from the hospital, he'll be fitted with a GPS monitor. But the reality is, he's no longer in custody. I know what you're thinking. The timing is hard to ignore. A man facing 16 felony counts collapses on his way to a hearing, and suddenly, he's free. It looks bad, but when you sit with the math, the logic is straightforward. He's not convicted. The county pays. The county can't afford it. Whether you're comfortable with that outcome or not, the legal reality is what it is. And then, just days after the hospitalization, his attorney filed something that could change everything. A motion for a full competency evaluation. And alongside it, a notice that the defense is considering a not guilty by reason of insanity plea. These are 2 very different legal questions. Competency is about right now. Can this man understand the charges against him? Does he know who the judge is, who the prosecutor is? Can he actually help his own lawyer build a defense? If the answer is no, the case freezes. He gets sent for evaluation, possibly treatment, to see if he can be brought to a place where he understands what's happening. If he can, the case resumes. If he can't, if there's no treatment that will restore him to competency, he may never be tried. The charges don't go away. They just sit there, unresolvable. Insanity is different. That's about whether at the moment the crime happened, he understood that what he was doing was wrong. It's not a loophole. It's a narrow legal standard that applies in very specific circumstances. Someone with advanced dementia, for example, who genuinely couldn't comprehend the wrongfulness of what was happening around them. His attorney described what he observed in meetings with his client. Significant confusion about the legal process, an inability to describe who the people in the courtroom were, including his own attorney. Difficulty maintaining a clear train of thought. Physical decline. Mobility problems. Hearing issues. A man who might need a wheelchair full-time, not just for court appearances. The attorney called him a sad and sympathetic character, not because of what he's charged with, but because of the sheer level of confusion he witnessed. A judge has ordered both the competency and mental health evaluations to move forward. The results, and what they mean for whether this 73-year-old man ever faces trial, are still pending. But here's where the case takes another turn. A family member, Ronnie Fletcher, married to one of Gary and Christina Sider's daughters, pushed back publicly on the idea that this is what the family always looked like. He said the grandparents raised 4 other daughters who are, in his words, successful members of society. He said the home used to be clean, functional, ordinary, a normal American home. And there are photos from 2023 that seem to back that up. Pictures of the grandparents looking well, clean, composed. Nothing like what law enforcement described after the arrests, which raises the question nobody has answered yet. If this family was functional a year ago, what changed? And when? Investigators say the family moved through multiple Ohio counties over the years. They even lived in Wisconsin for a time. There's reporting that Children's Services in a neighboring county visited the family once, and after that visit they relocated. Some believe it was deliberate, an attempt to stay ahead of anyone who might remove the children. The Attorney General himself said the family was good at hiding these kids. If that's true, whatever happened in that house didn't happen overnight. It built for years, alongside a pattern of knowing exactly when to disappear. 4 people arrested, 16 children removed, 1 defendant freed by a county too small to afford justice, and a family that looked normal just 12 months before the world found out what was happening inside. But this case is far from over, because as investigators dig deeper, as evaluations come back, as trial dates get set, the question isn't just what happened in that house. It's how it stayed hidden for so long, and whether the system designed to protect children ever had a chance of stopping it. If this case has you hooked, and you want to see where it goes from here, hit that like button and subscribe to Reopened Crime Scenes. We'll be following every update, every twist, and every revelation as this story unfolds. Because the truth, as disturbing as it already is, might be even worse than we know. Elizabeth Sider sits in jail, charged with 16 counts of child endangering. Her attorney has filed a motion asking the court to reduce her $300,000 bond. The argument is straightforward. She's 33 years old, no criminal history, never failed to appear in court. She's cooperated fully with investigators since the day of her arrest. If released, she'll wear a GPS monitor, check in with a bond officer, provide a stable address. And her attorney notes, the children who would have been the alleged victims have already been removed by the state. The danger, he argues, isn't present anymore. There's one more reason he gives for why she can't post bail. Elizabeth simply doesn't have the money. The extreme poverty prosecutors say defined the household makes any amount of cash bail impossible. According to her attorney, Elizabeth's only concern since her arrest has been reuniting with her children, and he argues that's proof she's not a flight risk. She has nowhere to go and nothing to gain by disappearing. If she doesn't show up to court, reunification becomes impossible. So why would she run? But what the motion doesn't dwell on, what it barely mentions, is something that changes the entire shape of this case. Elizabeth was 15 years old when she married into this family. He was 18. The marriage happened in 2008 in West Virginia. Court records show her parents and a judge gave consent. Marriage records show he'd completed 9th grade. She'd completed 8th. There's no indication either of them went any further. Their first child arrived just 2 months after the wedding, which means Elizabeth was already pregnant at 15 when the marriage took place. More children followed, steadily, roughly 1 per year for the next 18 years. 2 sets of twins among the 16 who survived. And 16 surviving children isn't the complete count. In November 2022, Elizabeth gave birth to another set of twins. Girls, Bailey Lee Sider and Faith Lee Sider. They were conjoined, born extremely premature at an estimated 24 weeks. Both died the same day at Riverside Methodist Hospital. Counting them, Elizabeth is believed to have given birth 18 times since she was a teenager. From the age of 15 to 33, she was pregnant or raising a newborn for the overwhelming majority of those years. No public record of having worked outside the home. No education beyond 8th grade. No evidence she ever lived independently of the Sider family at any point since her marriage. Her own attorney was asked point blank whether he considers her a victim in all of this. He didn't give a clean answer. His office isn't sure. He said she hasn't shown what would typically be described as victim behavior, but the investigation is still ongoing. It's an unusually candid thing for a defense attorney to say publicly, and it tells you that even the person representing her hasn't settled on how to frame her role in this. As of now, prosecutors haven't responded to her bond motion. Whether Elizabeth Sider walks free is still an open question. If this case is pulling you in, and you want to follow every update as it unfolds, hit that subscribe button for reopened crime scenes. These cases don't resolve quickly, and we'll be here tracking every turn. Make sure you don't miss what comes next. This case has drawn pointed comparisons to one of the most notorious child abuse cases in modern American history, the Turpin family of Riverside County, California. In 2018, 13 children were found shackled, starved, and confined inside their parents' home. Some so malnourished a 14-year-old weighed the same as a 3-year-old. David and Louise Turpin are now serving life sentences after pleading guilty to torture and false imprisonment. A retired detective who led the original Turpin rescue, Thomas Salisbury, has weighed in on the Ohio case. And what he sees worries him. The parallels are undeniable. The age spread of the children, the total absence of schooling or medical records, the confinement, the physical deterioration. Salisbury said the case immediately brought back a flood of memories. He described walking into the station after the Turpin children were rescued and seeing some of them standing in a courtyard with their arms raised toward the sun, as though they'd rarely been allowed outside. Their clothing was caked with filth, their bodies so emaciated they looked, in his words, like internment camp photographs from World War II. But Salisbury also flagged one crucial difference, one that may make the Ohio case harder going forward. In the Turpin household, the older siblings had managed to build something resembling an internal support system. They passed along rudimentary lessons to the younger children, informal schooling, shared coping strategies, a network of mutual protection that, despite everything, gave most of them the ability to speak, to read at some level, and to eventually recover with professional help. In Ohio, investigators say several of the children can't speak at all, and the oldest among them, an 18-year-old, can't write her own name. If that's accurate, it suggests a level of developmental deprivation that may run even deeper than what Salisbury encountered with the Turpins, where at least the older children had managed some self-directed education among themselves. Salisbury used the word heartbreaking. The Attorney General used the word feral. Both descriptions, coming from opposite sides of the country, are pointing at the same thing. On the question of charges, legal observers who've worked cases like this have noted that child endangering may not be where this ends. Each of the 4 defendants currently faces 16 counts, each a second-degree felony, carrying 2 to 12 years. But in the Turpin case, prosecutors didn't stop there. Once detailed medical documentation supported it, they pursued torture and false imprisonment charges. The kind of charges that carry life sentences. The kind that resulted in David and Louise Turpin dying in prison. Whether Ohio prosecutors follow a similar path depends on what the medical evidence ultimately shows across all 16 children, spread over several hospitals and trauma centers. But the fact that 2 children had to be airlifted, and one was in critical condition when discovered, has already raised the question of whether the current charges fully capture what happened inside that house. You don't necessarily need chains or cages to meet the legal threshold for false imprisonment or torture. Fear, confinement, and sustained deprivation can get you there too. Salisbury himself has said he believes there are potential kidnapping or torture charges just in the medical condition of the most seriously injured children, even without the physical restraints that were present in the Turpin home. There's also a practical reason prosecutors in cases like this tend to start with the charge they can prove fastest and build from there. Endangering children doesn't require establishing intent to cause specific harm, only that a caregiver's actions or inactions created a substantial risk to a child's health or safety. Torture and false imprisonment require a higher bar. Proof of a sustained, deliberate pattern of confinement or cruelty, usually supported by the kind of detailed medical documentation that takes weeks or months to compile across 16 separate cases. The initial charges may simply reflect what investigators could establish in the earliest days. More serious counts could follow once the full picture comes together. And investigators have said publicly that additional charges remain a possibility. 2 special prosecutors have now been brought in to assist Vinton County, an assistant attorney general with extensive experience in child cases and a prosecutor from neighboring Highland County. Both are being provided at no cost to local taxpayers. The case has outgrown what one small rural office can manage alone. The case still has to go before a grand jury, and in Vinton County that could take a while. The grand jury only convenes about every other month. All 4 family members waived their rights to preliminary hearings, which means the public won't get an early, detailed airing of the state's evidence. That will wait for indictment or trial, whichever comes first. The investigation is ongoing, and there's still a lot we don't know, including how many times over the years this family may have crossed paths with Children's Services without anyone catching what was happening, and whether Gary Sider Sr. will ever be found competent enough to face trial at all. But then there's the question that sits underneath all of this, the one that has nothing to do with bond motions or competency hearings or grand jury schedules. What happens to 16 kids whose lives may have been stolen from them long before investigators ever went through that door? Officials say the children are currently in the custody of the state and have been placed in safe environments with multidisciplinary teams coordinating medical care and behavioral health services. But safe is a word that carries weight only if someone's watching closely enough to make sure it stays true. The Turpin case proved that rescue isn't the same as recovery, and that the system built to protect children after the worst has happened can fail them all over again if nobody's paying attention. Salisbury's advice has been specific and direct. Put these kids in one place. Bring the professionals to them. Don't scatter them individually across the foster system, where oversight can quietly slip. That advice isn't theoretical. It's built on watching it go wrong the first time, on seeing the children he'd rescued from one nightmare land in another one. There's also the question of the 18-year-old. Legally, an adult. Functionally, anything but. A young woman who, according to investigators, cannot write her own name, who has spent most of her remembered life inside a house that was, by every official description, closer to a holding cell than a home. What services exist for her now? What happens when she ages out of whatever custody arrangement currently protects her? Nobody has addressed that publicly yet. And it may be the single most urgent question in this entire case that has nothing to do with the courtroom. Whether Ohio gets this part right, whether these 16 children get the kind of sustained, specialized, coordinated care that gives them an actual chance at something resembling a normal life, may end up mattering more than anything that happens at trial. The Turpin children, Salisbury has noted, are largely thriving today, years after the worst of it. But it took time, specialized professionals, and relentless oversight to get them there. Whether anyone provides the same for the 16 children rescued from Omar Street is, right now, still an open question. This case is far from over, and the answers that matter most won't come from a courtroom. They'll come in the years ahead, in the lives of 16 children who deserve a chance at something better than what they've known. If you want to stay updated as this story continues to unfold, subscribe to Reopened Crime Scenes and hit that like button. We'll be following this case as long as it takes, because the real story isn't just what happened in that house, it's what happens next.